a coalition agreement to be the foundational document for a coalition. So the Kenya Kwanza government is founded on the basis of these shareholder agreements. And when the deputy president, elected on the basis of those shareholder agreements, insists that those agreements must be complied with, he's called a tribalist and he's impeached. As Jesus would say, first take the log from your own eye. Impeach yourself as the government first for basing your government on a tribal agreement. Then get rid of your deputy president. Now, the National Assembly was scheduled to vote for the nominee to replace the petitioner before the Senate had voted. Again, senior counsel spoke to that, and I won't say much more. But what I will say is that last year, the High Court handed a decision, and I believe this was a 3 or 4 or 5 bench decision, and it's part of our list of authorities, in a case called Njiro and 11 others versus Kenya Kwanza Coalition and 18 others. It's part of our bundle of authorities. And this is what they said at paragraph 489 of their decision. We hold and find that the simultaneous holding of the position of Speaker with that of the leader of a political party and the leadership positions in the ruling political coalition, as is the case with the current National Assembly Speaker, Honorable Moses Wetangula, who is the leader of Ford Kenya, and a holder of key position in Kenya Kwanza Coalition, reasonably evokes appearance of bias. And I say this because bias is one of the tests Section 7 of the Fair Administrative Action requires you to look at. And I continue. And undermines his neutrality role as the Speaker of the National Assembly and the independence of Parliament as the symbol of democracy, negatively impacting on our democratic standards as envisaged by the rule of law, principle, and Article 10(2)(a) of the Constitution. And this is what they say. This dual role is unlawful and unconstitutional. I am aware that the National Assembly sought to stay that decision, and that attempt to stay was rejected by the Court of Appeal. There's a decision available on the Kenya Law website. And so, where you have a court decision stating that the referee, the man conducting this impeachment, the man issuing the decision, the man reviewing the motion is biased, is a violation of the rules of natural justice. One of the decisions we have submitted before you, and my good friend Mr. Dudley is a bit more eloquent on pulling them out of his head quickly. The court has said that any decision emanating from a decision maker in violation of the rules of natural justice is not a decision. Now, when you look at, Articles 95 and 96 of the Constitution, the process of impeachment begins or is initiated in the National Assembly. Article 96 then uses some very interesting words and states that the role of the Senate is to consider and deliberate, not on the motion, on the resolution. Those are the exact words of Article 96. And so a resolution emanating from a process shepherded, led by an individual who has been found to be biased is no decision at all. Now, the person who, this is one of the other criteria that the court is to look at, whether the person who made the decision denied the person to whom the administrative action or decision relates a reasonable opportunity to state the person's case. It is important, while looking at this particular question, to examine, according to the first petitioner, where his problems began. I call the court's attention to paragraph 65 of his further amended petition, in which he states that his problems emanated from exercise of his freedom of expression, Article 33, following demonstrations that led to the unprecedented in Kenya's history occupation of parliament by the citizens of Kenya. That is paragraph 65 of his petition. And the reason citizens of Kenya, who called themselves Gen Z, occupied parliament was that they said they were not being heard. Their participation was not meaningful, and the only solution they could find was to occupy the August House.